On page 4, we have Kellogg and Ghibaudo matter. This is D 2015-522043. We're on the record at the Regional Justice Center. Mr. Nelson, are you there?
Yes, Your Honor. I'm appearing in Anaheim on vacation, so I'm going to have my counsel, Alyssa Hiriji, present the motion.
Counsel, state your appearance, please.
Alyssa Hiriji, bar number 13895 for Tara Kellogg.
Okay, Ms. Cramer, are you there?
Good afternoon, Your Honor. Michancy Cramer from Mr. Ghibaudo, bar number 11545.
We're on the record. I see 6 boxes here, so it looks like we have the plaintiff, the defendant, we've got counsel. Who else is connected?
Good morning, Your Honor. Yasmin Kayomi, bar number 15942 of J.K. Nelson, also for Tara Kellogg.
Okay, that's fine. All right, good. Sorry it's taken so long to be heard. Had a busy morning. This is a request, a post-judgment request by Ms. Kellogg to ask the court to issue a show cause and conduct an indirect civil contempt proceeding. There was an opposition filed on the 19th of November. Ms. Hiriji, what do you want to tell the court?
Your Honor, for starters, we cannot see the court. I don't know if the court is aware.
Yeah, video for some reason isn't working.
Yeah, that's weird. That's unusual. You can't see the court at all?
Let me try this.
No, we cannot.
Weird. Is that for every hearing today, or is that just for this
Just the
one?
last couple since we had the problems with Miss Visa.
What do you see on your screen?
It just says family court and the FL in the circle, just like it shows Jonathan Nelson, JN, just like that.
Wow, that's so strange.
When I turn the video off, then it shows up, and I turn it back on, and the box goes away.
All right. Well, again,
I could hang up and disconnect it.
no. We're just this is fine. In fact, the administrative orders prefer in-person and video, but telephonic is allowed too. So as long as we can hear each other, that's fine.
All right.
Go ahead, counsel. Thank you for bringing that up.
Thank you, Your Honor. The February 1st, 2017 decree of divorce and the judgment from September 17, 2020 hearing should be enforced. In the November 10th, 2020 findings of fact, the court supportedly ordered that Mr. Ghibaudo owes $9,994.
All right. Everybody, all right, stop. Everybody but Ms. Cramer and counsel for Ms. Kellogg, please mute yourself. All right, we got to make sure that we only have one audio in each location, and then we're getting a bunch of feedback. So your statement was reverberating. It was hard to understand on our end. Okay.
No problem. Tara, can you mute yourself as well?
Yeah, I only need counsel. This is just a law and motion argument, so I just need counsel to be able to clearly address the court. Okay, so go ahead, counsel. You were referring to the original decree and then the post-judgment orders that were entered.
Exactly. Right now I was referring to the post-judgment order in which $69,924 was ordered in spousal support arrears for the period of October 2017 until April 2019. In addition, there was $47,500 in spousal support arrears from May 2019 through September 2020. And his spousal support obligation was modified to $2,500 a month starting October 1st, 2020. As of the date of filing this motion, Mr. Ghibaudo owed $144,258, and now an additional $2,500 for November's missed payments. Mr. Ghibaudo has been completely disregarding court orders for far too long, while my client is left barefoot, and she has to beg her relatives for money and loans and owes large outstanding balances to her previous counsels. He has only paid 7 total payments since March of 2018, only 2 of which were for the full amount. His contempt at this point is completely willful. Mr. Ghibaudo formed a new corporation on the same day there was a hearing on Ms. Kellogg's request to have a judgment assessed against Alex B. Ghibaudo, PC. His action should be used as an example of what should be defined as a willful violation of a court order. He has gone 35 straight months without making a spousal support payment as of the date of filing this motion, and has now hit the 3-year mark. As the court has previously found, he makes an average of at least $12,000 a month, so there's no reason financially why he shouldn't be able to make these payments. My client has to support herself, her daughter, and pay for attorneys and incur massive debt, whereas he can represent himself or have an attorney already on his payroll represent him. Now, the court has jurisdiction over this matter. I know there's been concerns about that over the past, as what is before the court today is collateral and independent from the appealed order. And Mr. Ghibaudo did not challenge the court's findings as to the reduced alimony of $2,500 a month. His appeal is just for the duration of the alimony. I also wanted to specifically mention or cite a couple of things that the court said in the transcript regarding all pending motions from the February 3rd, 2021 hearing. The court said, as time goes by, if there is no, and, I guess the failure to make payments as ordered, and maybe the court will feel differently about it. The court also acknowledged that he was in contempt. The court also stated that the court is not excusing if he is not in compliance with the support agreements that he made or the orders that have been made, he is at risk. And while the court's not taking up a contempt proceeding this month, we're something that the court can look into if that's necessary, okay? If he's not complying with his agreement and orders, it is at his own peril. Anyone who looks at this record will see he's had more opportunities than most to come and meet his financial obligations. Now here we are, almost a year later, and he has still not made a single payment, regardless of the fact that he has had countless amount of time. This keeps dragging out years and years and years, and my client is not getting any relief. In addition, he just filed his opposition a few days ago. He's an attorney. He has an attorney representing him. He should have filed the opposition within 14 days. He waited to the last minute so that counsel would not have an opportunity to properly respond to the argument that he made. So at this point, we're asking the court, can we actually get some relief for my client? And do we actually deem that it's shown that he's actually in peril now because he's continuing to disregard court orders? Thank you, Your Honor.
Okay, Ms. Cramer?
Your Honor, this is the same motion that she's filed. It's the same motion that you've ruled on twice now. These issues are on appeal. Does the court require further briefing from me or further argument from me other than your own orders from the other 2 times? We've already talked to Mr. Nelson about this. We've told him to withdraw these motions. We told him not to do this. It's on appeal, and he did it again. So in 3 times in 1 year, that she has no interest in any kind of relief, Your Honor. She won't get a job. She won't go back to school. She has 9 credits to get a degree, and she refuses. This is her job, is to go back to court over and over and over again. And the argument that she has incurred legal fees is disingenuous because we know that she owes Marsha Willick $100,000 and she owes Chris Reed $50,000. And that's on her, Your Honor. She's the one that keeps filing the same motion over and over and over again. So is there any other argument the court wants to hear from us?
Well, look, the problem that we have here is that, and counsel knows from, you certainly know because you've been involved in this case long enough to know, and another counsel reviewed all the hearings. We've had, it's even hard to count how many hearings we've had as it related to the dispute concerning the enforcement of the stipulated judgment, even issues of contempt. The reason why the court doesn't just deny this motion and take it off calendar is that there's ongoing noncompliance with the current order. The current order has a payment component to it, okay? The indirect civil contempt, or the request by Ms. Kellogg, is for the court to essentially take a jurisdictional affidavit, set a hearing, and have an evidentiary process to determine whether or not Mr. Ghibaudo is in contempt of the current order that's on appeal, and if he's in contempt, to sanction him $500 per count, or to consider incarcerating him to coerce compliance 1 to 25 days for each finding or count of contempt. Okay? And I cringe when I see the transcripts. Having a dialogue about what indirect civil contempt is, and whether it's Ms. Kellogg's right or whether it's the court's circumstance. The court has held several hearings. In fact, it was a period of time before the last judgment, but after the court case was assigned here, where we had hearings almost every few weeks to try to compel the periodic payments of support. Now, essentially, Ms. Kellogg is a judgment creditor. She has received judgments and she has an order for periodic payment. The $2,500 a month payment that's not being made is the problem that the court struggles as to what to do about. Okay? The appeal does not prevent this court from considering whether to have an indirect civil contempt hearing. The court can try to enforce its orders under the collateral jurisdiction of the court. But the court has commented about the fact that it's hard for me to find on my docket a case that has been as much of a time suck as this case has been over the last 3 or 4 years. And the court has adjudicated the rights of the parties, and those orders are on appeal. Both parties have sought appellate review of it. The court is not inclined, even if I found Mr. Ghibaudo to be in contempt, to put him in custody for not paying $2,500 a month to the plaintiff, a judgment creditor. And the court is not inclined to have a hearing in which we determine whether we have contempt, to determine whether to fine him $500 a month for the payments not being made. And so when the court is saying the right of indirect civil contempt as a tool to coerce compliance is the court's decision and the court's tool, not a right of the parties, that's what I'm talking about, okay? And, but to say that Ms. Kellogg has no right to try to persuade the court that this would be the time to do it, it is a galling circumstance to have an order that's entered. Even though it's on appeal, there's an ongoing payment obligation, a monthly payment obligation that's being ignored. That's not right, you know? And it pains me when I look at this case, but this is a call that the court has to make. Is the court going to have an indirect civil contempt hearing in which the outcome is whether he's in contempt and whether he's sanctioned with a nominal monetary fine or a sanction that the court is not inclined to impose on a financial debt? Okay? This is a financial debt of hundreds of thousands of dollars of disputed support arising out of a divorce decree. And so if the court isn't going to impose a sanction that it threatens Mr. Ghibaudo with incarceration if he doesn't pay this debt that's been adjudicated to him, then there is not a limited purpose, because it looks like Ms. Kellogg basically wants the court to have a hearing, find him in contempt, and put him in jail if he doesn't pay the $2,500. Well, that's not the court is not inclined to use that as a coercive tool in this type of case.
Your Honor?
No, I'll ask for questions in a minute. Okay. All of the commentary that was quoted in the response, the court has made a record concerning whether it would have a contempt proceeding or not. I would prefer, if we have a contempt proceeding, that it be after the appeals are resolved, so we know who's in the right as it relates to both parties' request to have those orders reviewed. And I can't even say, I don't know what the status is of those matters. I can't even say why. The first request after we made the decision in this case was almost a year ago, wasn't it? For that relief. So the court isn't really arguing with any of the points that counsel is making in requesting some sort of relief from the court. Ms. Kellogg wants the court to be basically her agent or her tool to enforce the judgments that have been entered against Mr. Ghibaudo. And to the extent to which the court is willing to do that is within its court's discretion. Okay. I look and I have many deserving cases that involve a lot more important matters than financial disputes between parties that warrant the court's attention. So, counsel, do you have any questions for the court?
Yes, Your Honor, I do. I want to know what my client can do in the meantime, because, as you said, this has been going on for years. It's been before the court so many times, and if the court is unwilling or feels that it's in their discretion, they don't want to put him in jail or, sanction him for contempt, then what is supposed to actually push him to make these payments? Because he clearly doesn't want to. He's not doing anything to make the payments. The court said at that last hearing that I was citing to in February that, he will be in peril. If those aren't the remedies, then what does the court define as peril? What can he do? He's purposely evading payment. The fact that he changed his LLC the way that he did specifically so she couldn't get a judgment against the right LLC shows this is completely willful. So at this point, yes, I agree. It's ridiculous that my client has had to go back to court again and again and again. But what else is she supposed to do? Just sit down, lay down, and let her ex-husband attorney completely get away with everything? He should be held to a higher standard, not a lesser standard. I've seen cases where we have simple custody motions where you're getting charged $500 in each contempt, and those were barely willful. Here, he's making over $12,000 a month. There's no reason for him not to be paying. He can afford it. So when is the court going to impose sanctions or, I guess, put him in jail for that matter? And that's not what my client necessarily wants, because that would hurt her from making money financially. And Ms. Cramer also brought up the fact that my client is willfully unemployed. The court has already imputed an income to my client for that fact, and my client, as you can see from her FDF, is disabled, and we have provided evidence of such.
Look,
There's been no evidence.
The court isn't giving any consideration or weight to any of the arguments about her circumstance, okay?
Okay.
The court is looking at her as a judgment creditor. If this was just a civil judgment that she had and there was no order for the $2,500 payments, you wouldn't even have a right to be here. You would be just like any other number of a person with a civil judgment that would be going and trying to be creative as it relates to ways to collect on that judgment by any lawful means under Nevada law, okay? In a civil case, if this was a civil case where you had a client that obtained a judgment against the defendant for $150,000, you would not be coming back to the court and asking him to help enforce the payment of that judgment. You happen to be in the unique circumstances of having a client who has a judgment arising out of a spousal support judgment, who has a specific order for periodic payments. That's the only reason why you have any basis to come here at all, okay?
But Your Honor, that means that my client does have a right to be here, and also it is different than other judgments because this one is not dischargeable.
Right, and the court also is sympathetic to your client that there is a component of the order, even though the orders are on appeal, for a periodic payment of $2,500 a month.
Your Honor, if I may interject, I'm just curious. I mean, we've hammered on it, and you haven't really addressed it. What's the peril that Mr. Ghibaudo is going to be facing? Because that was specifically in the order that Ms. Cramer, conveniently omitted in her limited and late opposition.
Well, I have no idea. I have no idea what's going on I only know what's going on in my case. This looks like a dispute that's going on more than one front. That's my intuition on this, okay? That there could be an appeal that's going on, there could be bar complaints that are going on. I have no idea. I only know what's going on in this case. I can't remember exactly, but he's an officer of the court. I can tell you right now that as a member of the bar, I just sent in my certification saying whether or not I'm subject to any particular orders of support. Am I compliant with my orders of support? Do I have any of this thing? I mean, I haven't lost. I expect that this probably is. He's in peril as it relates to the appeal. He's in peril as it relates to his status as a member of the bar. That's kind of the way I'm looking at this, in that you have orders in play and judgments in play that, as an officer of the court, all of us are officers of the court, other than the parties in this case. Whether we have judgments and whether we are honoring the ordered obligations, those are things that affect our ability to practice, right?
I agree, Your Honor. So to clarify, though, you have no intentions, even though 9 months ago in your order you said they were denied without prejudice, you have no intention at this point in time of enforcing your order or trying to put any feet to the fire as far as Mr. Ghibaudo is concerned. So, in other words, he can continue to disregard your order as just a simple piece of paper.
Yeah, you know, I understand why you might put it that way, but if you were in this case longer, you would know that that's a bunch of baloney, because I did methodically use the power of the court by having hearings every week to make sure that weekly payments were made, by having monthly payments made. Am I reticent to put anyone in jail because they owe money to somebody? Yes, I am reticent to put people in jail for that purpose. And you have a greater chance of going to jail if it's a child support obligation as it is a spouse's support obligation. And I'm not going to get into some academic discussion concerning that. But if the court is going to dedicate time, which I don't have, by the way, to have a evidentiary proceeding to address a show cause hearing, then the court's going to have to consider what type of sanctions are we going to apply. I know you're kind of both comment on the case. I don't really care, but you have a judgment in the amount of $150,000 aggregate, probably. If the court determined every payment that was not made on the month for the course of the year as a $500 sanction, that'd be about $6,000 a year. And the court would be dedicating a half a day, and we've never been able to do anything in a half a day in this case, not even the other contempt proceedings. And so, am I saying that under no circumstance would the court issue a indirect civil contempt sanction to try to get Mr. Ghibaudo to pay your client the $2,500 a month? I don't know. I certainly didn't feel that I should have a contempt proceeding months ago, and you can tell that the court isn't excited about having a contempt proceeding today about it. Because the purpose of an indirect civil contempt proceeding is to coerce the compliance with the payment of the court order. I have two tools, two blunt instruments. One is a $500 sanction, which has no coercive power in this type of a case. And the other is to put someone in jail because they owe money and are not paying as a matter of spite. And frankly, that's a pretty effective tool in getting folks to pay. But I also think that judges who do that with impunity are, I think that you need to check yourself every time you're thinking about trying to punish somebody for not paying a debt that they don't think they owe. The appeal, maybe I'd feel differently if the appellate process was over and there was no argument about whether or not he owes these monies or whether the settlement that he made was enforceable. That's still pending, is it not?
Your Honor, the appeal was never on the amount; it was on the duration by Mr. Ghibaudo.
It's an appellate matter that's pending.
So, can I ask, Your Honor, how do you balance not providing Ms. Kellogg with an evidentiary hearing for an order to show cause, but yet Mr. Ghibaudo's counsel sent this court on a goose chase earlier in the year saying, oh, we weren't served the writ of garnishment. We had not one, but 2 half-day hearings. Yeah. And you know the kicker is on that, Judge? The day you went forward and continued with the hearing, Mr. Ghibaudo changed his LLC. Yeah. So he was good, he just essentially sent this court on a goose chase, but yet you won't give my client the time of day. So I'm just wondering how you balance that out. You have a client that just, regardless, he didn't care how you ruled after the 2-day hearings because he was already set. He had already changed his LLC and never brought one iota of that up to the court, Your Honor. And again, we'll go through those processes as a judgment creditor, but he'll probably do the same thing. And the tool that you have, the two tools, the $500 fee or the jail, are very powerful, Your Honor, and we're asking you to exercise them. Set a hearing, because you have given the courtesy, you have given the extension to Mr. Ghibaudo to say he wasn't served a writ of garnishment when we had a affidavit from a constable saying that he was served. We had testimony from a resident agent that she was served. We went through that whole exercise for nothing. And I'm asking you to... You got to do something, Your Honor, because Ms. Kellogg is continuously prejudiced by your failure to act. And I hate to, I say that with all due respect, Judge Ritchie.
That is not relevant to this argument, but in that case, Your Honor, with regard to the garnishment, Tara and her family friend, who was the former registered agent, committed fraud.
Ms. Cramer, look, please, I resolved that issue already, okay? We had a hearing. The court found that there was adequate cause for a hearing. We had the hearing. The court from Mr. Nelson's point of view, you know, he would like the court to think that it was unnecessary, but the court made it necessary, okay? The affidavit of Ms. Kellogg that's jurisdictional is the one that she signed. Actually, it's not, I mean, there's a signature on it. There's, you know, I don't want there to be any kind of technical defect, but there is a purported affidavit that was filed and attached to the filing that was made on, I think you did this, Mr. Nelson. This was the October 18th, right? The affidavit for an indirect civil contempt is the jurisdictional affidavit. She says that she obtained the judgment. Again, that's just background. She says she's not received any payment toward the judgment, which isn't a basis to have a contempt. Number 4 is the one. Alex was ordered to pay me a total of $2,500 a month in support beginning March 2018. He made 7 total payments, and since October 18th, he's made no payments to spousal support. Those provisions, 4, 5, 6, and 7, are, we have a clear order. We have a jurisdictional affidavit stating that there was non-compliance. Obviously, we have notice of these orders. All the other stuff is background. And so she wants the court to hold him in contempt for the failure to pay those $2,500 a month, right?
Correct, Your Honor.
All right.
That's what she's wanted all along, Your Honor. I mean, you can see, I guarantee you, Judge, that this video is going to end up on Facebook with Veterans in Politics and Steve.
Look, that doesn't bother me. I've been doing this for 22 years.
Oh, it's not
I have to tune that stuff out. I do tune that stuff out. I don't care. What happens in the 4 walls of my case is going to be what I deal with. You know, litigants.
Your Honor,
litigants will deal
it's
with
aimed at me and it's aimed at Alex. So it has nothing to do with this case.
Whatever. It is a. I would say that I don't know anything about it. You alluded to something on a Facebook page in your opposition that was filed. I don't know one way or another, but that certainly does not help the equitable piece of the case if it goes to a hearing and there's some argument that the court should use its, and I would agree, Mr. Nelson, it's great power. It's great power to put somebody in jail because they're not paying a debt, okay? And it's not something that should be done without good cause. And I completely respect your argument that the continued non-payment of the $2,500 a month could be considered good cause to exercise that authority. I can tell you that on this occasion and the previous occasions, the court has articulated the reasons why it wasn't going there again right now, okay? And what's your client left with? Your client is left with, trying to collect on the judgment, and then, I don't know. I'm looking at my trial and evidentiary calendar. I actually do not even have a half a day that would be available for this until February. Okay?
Mine with February.
No, I'm just saying February. And those are cases that are deserving, cases that are pre-judgment, cases that are, and I'm not talking about setting this matter for an hour. I'm saying that if there was an indirect civil contempt hearing, and I said it in the ordinary course, it would be February. All right?
Yeah. We need something, Your Honor. We need something to spur Mr. Ghibaudo's compliance with court orders.
What is the status of the appeal? Do you have any information concerning the status of the appeals?
Your Honor, I believe Mr. Ghibaudo, it's his time to file a reply to our response and opening brief. But we're still in the briefing.
Your Honor, the other issue I have is just like with the supposed service that she committed fraud against my client with her friend, the registered agent. I'm not going to put up with Tara's argument that she has a disability when this court's already ruled that she's not disabled.
See, none of that stuff matters.
And
the issue
yes,
is the elements of an indirect civil contempt proceeding are do we have a clear order? Is there notice of the order? Is there compliance with the order? And is there a legal or equitable defense? All that nonsense is not relevant or material.
Right, but we do have a right to conduct discovery on our defenses, and we do have a right to conduct discovery on the equities in the case, and I'm not going to be like pushed up against the wall and not being allowed to conduct discovery. So, and I already know Tara's going to come back with her lie that she can't appear for a depot because she alleges she's disabled. I mean, she can go, sleeping around with every half of California.
Your Honor, come on. Let's, Miss.
How dare you? Okay, stop.
Your Honor, if I may,
you're an attorney.
If I may, Your Honor.
Stop talking like that. If you guys were in court, in my court, sitting here like this, and you acted like that or said things like that, I mean, first of all, you guys be mortified and embarrassed to even do something like that. Don't do that. You're an officer of the court. None of that stuff is relevant or material to the issue that we have, okay? The court left this on and had a hearing because there is discretion for the court to consider having a hearing, to consider whether there should be indirect civil contempt. The court, presented with this dispute, has talked about the history of this case and talked about the policy behind trying to coerce compliance with this, and has explained why it did not issue a show cause and set up a timeline for a hearing on this. If the court set a timeline on a hearing of contempt, the court would not be reopening this matter to relitigate every issue that arose out of the divorce case or even the post-divorce litigation. It would only be about the jurisdictional piece of this, which is there's a clear order, is there compliance or violation of the order, and is there a defense? And it is not an equitable or legal defense to say that she doesn't need ordered support. The court has already ordered the support, and he hasn't paid it. No. You couldn't even bring it. It's not even a line of it's not a defense to that action. Okay.
But Your Honor, we would be entitled to conduct discovery on our equitable defenses, and in the last hearing you opened discovery and her parents refused to comply. And so I'm not going to tolerate that this time, Your Honor, and I'm not going to be rushed into a hearing without my client's rights being respected. And so to say we're going to have this done in February, I know they're getting all excited. Mr. Nelson had to say he was on vacation when he's actually been here the entire time. But Your Honor, we're not going to be pushed into it. She's going to appear for a deposition. She's going to do it in person, and so are her parents.
Well,
because my client
Your Honor, I know sales.
I don't understand how her parents have anything to do with this. We are focused, just as Your Honor said, we have an order, and that is what we're focused on. We're not worried about the disability. There's already imputed income.
It's not about the disability. It is about the fact that she continually tries to harm my client's business. She has cost us money at the firm because she won't shut up online. She goes and posts these videos, just like this one.
Your Honor, can I just ask Ms. Kramer's response?
And your client puts her on Facebook and attacks her all the time.
Why are you guys acting? Why are you, Ms. Kramer? Why are you? What you're acting? You're out of order. You're acting unprofessionally in interrupting both the court and counsel to make points that are they're not. Look, please don't do that.
Your Honor,
I'm trying very hard to. I expect you guys, whether you're here or whether you're sitting in your kitchen or your office or wherever the heck you are, to act properly. Okay?
I think my co-counsel here takes disrespect to the fact that Ms. Kramer doesn't know where the hell I'm at. I am in Anaheim, California, with Disneyland. I'm taking
don't take the bait on that stuff.
But
okay?
we're not. She's getting my back because Your Honor, here we have. Opposing party fails to abide by ADCR Rule 2.2E. She didn't file a timely opposition, but yet she wants her day in court. She wants to, jump up and down about discovery. But if you review ADCR 2.2E, failure of an opposing party to serve and file a written opposition may be construed as an admission that the motion is meritorious.
The court is not considering saying that that your client does not have the right to ask the court to conduct an indirect civil contempt proceeding. That's not, the issue is whether the court will take up the jurisdictional affidavit and set in motion an evidentiary proceeding that would evaluate whether or not indirect civil contempt sanctions would arise. We have the orders in the case. Now, I want to ask you this, and you can just tell me, the affidavit that is attached to the motion, the jurisdictional affidavit, this is a technical requirement for the court to even consider indirect civil contempt. It has some form of signature. I don't know how it's signed. I can't read it because there's no legible signature. I'm sure that you had to physically sign that affidavit in your, for you to file it, right?
Your Honor, I can clarify that. What we use is we use a DocuSign service through a company named HelloSign. So it was sent to our client to her email directly, and there's a certification showing exactly where it's sent, what date she signed it.
Where is that?
So that's on so right after that certification, right after the affidavit,
Right.
the following page is that HelloSign certification,
So
where it says
even
arbitrary.
though there's no signature on the document, that HelloSign attests that it was reviewed and signed and she owns that affidavit.
So there is a signature on the document. I do not know why it is so minuscule, but I can see it on my computer. It's just very, very tiny, but there is certification that it said it was signed by her on 10/4/2021 at 10:14.
All right, that's
Yeah.
good. All right, that's good. All right, so the The motion that was filed asked to enforce, with the court's use of its power of indirect civil contempt, the order that requires Mr. Ghibaudo to make periodic payments on the spousal support judgment. The affidavit that was filed with the filing in October is jurisdictional and makes a specific allegation at the paragraphs that I mentioned, that there were no payments or that the payments were not being made as ordered. The court finds that there is a clear order that requires periodic payments. There's an affidavit that alleges no periodic payments, or that periodic payments are not being made. And there's obviously notice of the order. And it's a factual dispute as to whether there's a legal or equitable defense. The best defense to any kind of allegation of contempt is payment. I mean, I'm sure it occurred to you, Mr. Nelson, that if the court issued a show cause and he started paying the $2,500, there wouldn't be any hearing for contempt, okay? But the court has looked at this case and expressed a reluctance to conduct a contempt proceeding. The court concluded that it would not conduct an indirect contempt proceeding months ago. That was on the eve of resolving the most recent request for judgment and the matter going on appeal. That these requests that are made have a cumulative effect. They have a cumulative effect as it relates to whether or not the orders that were entered are being followed. I can't think of any explanation as to why it would be legitimate not to pay the periodic payments and monthly payments. And the court, feels that if we're going to have a hearing to impose the sanctions from indirect civil contempt, whether it be a monetary sanction or a threat of the coercive power of incarceration, the court should be prepared to apply those type of sanctions. And the court has explained that the plaintiff essentially is a judgment creditor, and that the defendant is refusing to pay, and that these judgments, or at least some fashion of this judgment, is on appeal, and that the court needs to evaluate whether it makes sense to dedicate the judicial resources to having a contempt proceeding in the case at this time. The court has discretion to decide to take it up or not take it up. It's not the right of the litigant to ask the court to use indirect civil contempt. In this particular case, There is no, it's hard for the court to understand how the non-payment of the monthly obligations month after month can be justified. And the court is going to issue a show cause and set this matter for a hearing. The court, finding that there's adequate cause for a hearing, does reopen the case. The court recognizes that there are certain rules that would apply as it relates to requests for discovery, and Mr. Nelson, I think you'll avail yourself of, I guess, the Discovery Commissioner if there's any disputes concerning the scope of that particular discovery. But discovery is going to be open for a period of time. The court is going to set this matter for Monday the 14th of February, or Tuesday the 15th of February at 1:30. Discovery will be open until February 4th. The court's going to issue an order setting this matter for evidentiary proceedings on indirect civil contempt for the 15th of February at 1:30 with the discovery cutoff on the 4th. At that time, Ms. Kellogg's counsel will put on a case to establish by clear and convincing proof that there is a contempt of the court order regarding periodic payments. And if there is contempt found, then the court will consider what, if any, sanctions are appropriate. Any questions?
None for me, Your Honor.
Counsel, you're going to submit a show cause. You'll formally serve the show cause on Ms. Cramer, and the matter will be pending.
There is one concern that I had, and I don't really know how. I just want to make sure that my client is protected during any potential depositions. So I would like to.
I'm leaving. Look.
As well as my parents.
I'm not issuing any orders.
As my parents. My 80-year-old parents.
Again,
Yeah, your 80-year-old
assuming that discovery is going to happen. We're not ruling on any. We're not issuing protective orders or making any rulings regarding discovery. The matter is open, which means discovery can be attempted or requested, and the request to limit that discovery on whatever legal ground or defense there is can be had between now and then. Okay?
Thank you, Your Honor.
We're done for today.
All right, thank you.